Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website and those who will be viewing this program on C-SPAN as well. For those in-house, we would ask that kind courtesy to see that our mobile devices have been silenced or turned off. And, of course, for those watching online, they are welcome to send questions or comments at any time, simply emailing speaker@heritage.org. And we will, of course, post the program following today's presentation on the Heritage homepage. Leading our discussion is Elizabeth Slattery, Legal Fellow in our Edwin Meese III Center for Legal and Judicial Studies. Mrs. Slattery writes about the Supreme Court, separation of powers, judicial nominations, and a variety of constitutional issues. She also manages Heritage's appellate advocacy programs, including moot court sessions to prepare litigators for oral argument in cases pending before the Supreme Court. Please join me in welcoming Elizabeth Slattery. Elizabeth?
Thank you, John. President Donald Trump selected Neil Gorsuch, a judge on the 10th Circuit Court of Appeals, to fill the Supreme Court vacancy left by Justice Scalia's passing last year. Judge Gorsuch has spent the last 10 years writing countless opinions and establishing himself as a thoughtful jurist who pays close attention to the text and original public meaning of laws and the Constitution. He has an impressive judicial record, sterling academic credentials, and years of government service, including clerking for Justice Anthony Kennedy. But what kind of colleague, friend, and boss is Judge Gorsuch? We'll hear from a panel of his former law clerks today, but first we'll hear from Mark Hansen, his former law partner and boss, who's been quoted as saying that Gorsuch was born with silver hair and an inexhaustible store of Winston Churchill quotes. Mark Hansen is a partner at the law firm Kellogg Hansen. With more than 30 years of experience, Mark has been the lead trial counsel in cases across the country representing prominent clients such as the U.S. government, the Kingdom of Saudi Arabia, large corporations including General Electric and Verizon. He's tried more than 30 cases to verdict and has argued more than 20 appeals. Mark previously served as an assistant U.S. attorney for the Southern District of New York and as a law clerk to Judge William Timbers of the Second Circuit Court of Appeals. He's a graduate of Dartmouth College and Harvard Law School.
Thank you very much, Elizabeth, and good afternoon, everybody. I wrote a title for my little talk today. I hope it should be about 20 minutes. The title is, I Knew Him When. Because we all know the phenomenon of somebody who hits a home run to win the World Series or wins the Powerball, emerges from obscurity, and suddenly everyone asks the question, who is this person? What do we know about her or him? And of course, somebody who's nominated to the United States Supreme Court, that's an extraordinary thing. And when Neil Gorsuch becomes that nominee, obviously all eyes turn to Neil. And so the reporters and the public tracks back to the early days, to the people, the little people like me who knew him when. First story, vignettes of what Neil was like before he became famous. And, me, like everybody else, we love to get a little bit of reflected glory. I have a story that I love to hear from a friend of mine who's a legal academic. Among other things, he argued a very prominent case for the Haitian refugees a number of years ago at the U.S. Supreme Court. And as he finished his argument, he came out to those iconic Supreme Court steps and was surrounded by TV cameras and reporters all hanging on his every word. And from stage right, this figure came striding toward him saying, I want to congratulate my best friend, my good friend, the man who worked so tirelessly with me to save the Haitian refugees. My brother, my friend, he leans close, he puts his arm around my friend, the academic, gets in the picture frame, turns to him and says, what's your name? Well, I know Neil Gorsuch, I know his name, and I worked with him for a decade. We practiced civil trial law together across the United States in a variety of cases, and I'm happy to be here today to tell you what that experience might suggest to you and to the public about the kind of Supreme Court justice Neil Gorsuch is likely to be. Unlike our president, who's going to be turned out either 4 years from now or 8 years from now, he can't serve longer than 8 years, Neil Gorsuch, who's being appointed, nominated, and if confirmed to the Supreme Court, could be there for 40 years, 50 years. I mean, think about it. Neil is only 49 years old, and he's in great physical condition. Do not let that gray hair dye fool you. He's been applying that since Georgetown Prep, just so he could be considered for a Supreme Court nomination someday. That's how careful Neil Gorsuch is. Obviously, the best clues for what kind of justice Neil Gorsuch will be are in the 800 published opinions he's issued as a judge of the United States Court of Appeals for the 10th Circuit. And with us today are three distinguished former law clerks of Judge, soon-to-be Justice Gorsuch, who are going to describe for you what those opinions tell us about his way of being a judge. I will tell you that we've been fortunate enough at our little firm to work with two of those three. I'm sorry we missed out on the third. And Neil has done this fabulous job early on in his tenure as a judge of really taking care to find the very best law clerks. And he sent a lot of them off to the U.S. Supreme Court in sort of a virtuous cycle. He gets great people, and it helps him do a great job. And that's actually something you should take note of. On the Supreme Court, he's likely to do the same thing. I mean, think of it. Neil has written 800 majority opinions. That's about 80 a year. The U.S. Supreme Court takes up roughly 80 merits cases a year. So we learn a lot from the opinions, and Neil writes well. I mean, there's been a lot of commentary on how Neil writes. He's a good, careful writer who tells us what he thinks and why he thinks it. And if you're really a law geek, you can pull down those 800 opinions and pore over them, as many scholars have done or will do. I will tell you, I don't want to steal the thunder of the law clerks, not all of them are Marbury versus Madison. There's, for example, the AM versus Holmes case, where Neil took up the pivotal question of whether a student has the right to burp in class. And now scholars can consider whether burping's a right, where Neil found that right, and whether there are reasonable time, place, and manner restrictions that apply to that right. But joking aside, we have, in addition to Neil's 800 opinions, a decade of service as a private lawyer. We know that Neil Gorsuch was a serious, committed civil trial lawyer with an active nationwide practice. And that was pretty much all he did for the 10 years between his student days and his clerkship days and his time on the bench. He didn't get active in politics. He didn't have a lot of hobbies. He was a hardworking civil trial lawyer. I would say that there's very little that's been written about that time in Neil's career. There's certainly very little that's been written in depth. There's been a lot about what he put in his yearbook at Georgetown Prep. There's been a lot about his time on the bench, but not that much about his time as a civil trial lawyer. But I would argue to you today that that experience as a civil trial lawyer, working in the trenches of our court system, is as telling about what Neil could be like as a justice as anything perhaps other than his service as an actual judge. I'd certainly put it way ahead of whether he wrote silly things in a newspaper column at Columbia, for example. Any of us who didn't do those things or should be ashamed of ourselves. But let's set expectations at the right level. Neil had a great talent for civil trial law, and he was headed for a notable career as a trial lawyer, and a lucrative one at that. But he was still a pretty young, rising lawyer when he left the practice at age 38 or 39 and went into public service. That said, and meaning no disrespect to the 8 current sitting justices, I think it's fair to say that Neil's deep and lengthy engagement with our civil justice system exceeds that of any nominee to the United States Supreme Court since John Paul Stevens in 1975. Well, you do the math. That's 42 years ago. We've gone 42 years since we had a Supreme Court nominee with as much experience in our system of advocacy, our system of litigation, as Neil McGill Gorsuch. Our Supreme Court is comprised today of distinguished lawyers, most of whom have never tried a civil jury case to verdict. Those of us who try cases would argue that deep experience with the thing that we use to resolve our disputes is of absolutely pivotal importance to those on the bench. Facts matter. Records matter. What happens in litigation is messy. It is human. It is far from an antiseptic process. It is far from an abstract intellectual exercise presented in the form of a cold record to an appellate court. Cases arise from life, from lived experience. You know, the famous Holmes quote, "The life of law has not been logic, it has been experience." Well, those of us who try cases really know that very well. Neil Gorsuch has a strong grounding in our system. He understands its strengths, and he understands its weaknesses as well. He understands how the law affects real people. He's been an advocate for real people, everyday people as well as large corporations, and he's seen it from all sides. This has to be a big plus for anybody who is going to go and take up a position as a Supreme Court justice. What else do we know about Neil from his decade in practice? Well, we know he worked hard. For you young whippersnappers out there who are wondering, how do I get to the U.S. Supreme Court? I'm here to tell you that hard work is a big part of it. You hear a lot about work-life balance and so on, but I went back and checked. In his years as a partner, about 7 years as a partner, Neil billed between 2,400 and 3,000 hours a year. That's billable working time. It's a lot. He actually billed substantially less as an associate, which is the support I use for the argument that we partners work far harder than our associates. But Neil was a hard worker. And why do I think that's significant? Because once we elevate folks to the Supreme Court, there's really no check on how hard they work. We rely on them to work as hard as their conscience dictates. That's a hard job. It's enormous amounts of material to master, enormous complexity to the issues. We've all seen or heard or read reports about how justices in history, and I'm certainly not talking about current justices, but there have been justices over the course of history who, for whatever reasons, health, age, boredom, have some kind of checked out, let their clerks do the work for them. I think we have enormous confidence that that's not going to happen to Neil Gorsuch. He is a constitutionally hard worker. Two, he's been exposed to a lot. That we know from his time at practice. Not only was he an active trial lawyer, but he worked for both sides of the V, as I like to characterize it, plaintiffs and defendants. He worked in state courts. He worked in federal courts. And I'll just give you a sampling of some of the cases he worked on with me. There was a case that involved refund anticipation loans issued by an accounting firm. Loans where people could get an advance on their government refund. That's the good part. The bad part was they had a sneaky 400% interest rate affixed to them. And Neil and I and others put together a class action. I know that word may be anathema here at Heritage, and hopefully I won't be struck by a bolt of lightning, but we represented the plaintiffs in that case. And we tried to get a class certified because we thought these loans were really abusive, and ultimately they were stopped. Our class representative in that case was this absolutely impressive Army Master Sergeant, a female, an African American, and she agreed to serve as a class representative for one reason and one reason alone. She thought it was the right thing to do. And I remember how deeply, Neil and I felt about trying to get justice for this woman and the other people who'd been victimized by this scheme. So when you read reports about how Neil was a lawyer for corporate interests, remember that case because it's a pretty telling indicator on the other side of the V. There was a theft case for a small Iranian immigrant doctor who owned an airport outside College Park, Maryland. He owned this airport that had a gravel pit on it, and a big construction company was stealing the gravel. Neil took that case like a bulldog and obtained a great result for that doctor. There was a very large Section 2 antitrust case we brought in Paducah, Kentucky, involving a monopolist who was squashing smaller rivals. Neil helped obtain the largest civil antitrust judgment ever affirmed in U.S. courts. Of course, I was the lead lawyer, but nobody's interested in me today, so we'll make this about Neil. And finally, there was a tortious interference case for a beloved charity hospital here in Washington that was put out of business by a rapacious insurance company. And Neil and our colleague Priya Ayer obtained a stunningly great verdict that helped get the hospital back some money as a result of that abusive conduct by the insurance company. But it wasn't like we were always Robin Hood. We were also defendants, too. Neil defended a monopolization claim brought by an upstart telephone company against what was then Southwestern Bell, is now AT&T, down in Texarkana, Texas. He defended a derivative action brought against a leading entrepreneur in Delaware Chancery Court when the entrepreneur was allegedly taking too much money out of a group of theaters called Regal Cinema. There was a case against Ford Motor Company and some of the car designers at Ford having to do with rollovers of Bronco 2s, where we had to defend people who were honest, hardworking people who tried to do a good job on those cars, but the plaintiffs said they were deliberately trying to create bad cars that killed people. Neil defended a case for a leading insurer when doctors came after the insurer, saying the insurer refused to pay claims that the doctor had validly presented when he did 50 different operations supposedly on one hand. That's just a sampling of the cases. There were many, many more, but I hope it gives you some sense of the breadth of the practice, the variety of the practice, the subject areas that Neil worked in. I think you couldn't find a Supreme Court nominee who had a broader litigation experience or a deeper grounding in what we do. When he takes his seat on the court, he may be unique among his colleagues in his broad firsthand understanding of how the law affects real people in real life. I just think that's a huge asset for anyone who's going to be asked to resolve the important questions our Supreme Court is asked to resolve. Well, next on my list of Book of Virtues, as I like to call them, my William Bennett approach to this speech. He's got a very independent streak. We know that from his time in practice. Now, usually when we say that at our little firm about young partners or associates, it means they're contrary and difficult to work with. But that's not what I mean when I talk about Neil here. What I mean when I talk about Neil is that he does what he thinks is right every time. For example, he came to our little firm. Instead of going to the standard, traditional big law firms that most people with his backgrounds go to, he decided he wanted to go someplace where he'd get more experience faster and he could help build something. That was an unconventional choice, but he made it and he never looked back. He chose to ground himself in trial work rather than the appellate work that a lot of people with the sort of beautiful clerkship resume type backgrounds, people like Neil, have. Instead of confining himself to that abstract exercise, he dove into the muck and mess of real life litigation, which was an unconventional choice. Chose his independent streak. He chose to work for plaintiffs as well as defendants. You know, a lot of lawyers, they don't want to work for plaintiffs. You know, they think, well, really, defendants are always right. I will tell you, my dad was general counsel of a major company. I grew up thinking defendants were always right. Didn't take me long in the practice of law to be disabused of that. No one is always right. Sometimes plaintiffs are right, sometimes their defendants are right. And our system depends on the ability and willingness of lawyers to take both sides, to look at things from both sides of the street, to not be a doctrinaire or cause-oriented lawyer, but to really take up the cause of the client and bring the client the best result you can obtain for the client, consistent with the rules of ethics and the law. I think it's also extraordinary that Neil, on the cusp of a really great career as a civil trial lawyer, a very lucrative career, gave it all up. He forswore it and went into public service. That shows his independent streak, too. He felt like calling to do public service, and he turned his back on what would have been a very lucrative and satisfying career. So at the end of the day, these and a million other things I could cite to you are evidence of the fact that Neil's not going to do what anybody tells him to do, whether that's the president who nominated him or anybody else. Neil Gorsuch is going to do what he thinks is right. He's got a firm compass that guides his actions. Number 4 on my little list of virtues is that Neil is level-headed in his demeanor and has a good temperament. You know, I'll just tell you a couple of stories on that one. A sense of humor helps, right? We live in a pressured world. We have contentious activities. We fight with people for a living, right? That's what litigators do. It helps to be able to deflect that tension with humor. So when we were down in Charlottesville to try a case for Sir Bernard Ashley against a big accounting firm, we told our office manager to go find us economical office space. And Neil showed up ahead of me down in Charlottesville, and he looked around this basement. It was a basement. Had these tiny little cubicles you couldn't even turn around in. Our office manager had sort of done too well. She had gotten us a very economical trial space. And Neil promptly turned around, looked at the space, said, "We'll call it Das Boot," because it looked like a German submarine. And the inside was like a little corridor. Now, I know this is being televised. I know people are here. Please, no one write that Neil is an admirer of the German Navy. Please, please, please. He was not an admirer of the German Navy, but we were all familiar with the movie. And it was a perfect characterization of our little trial office. So from henceforward, it was always, "We'll meet you at the Das Boot at 2 o'clock, okay? Tell the witness to go to Das Boot at 3:15. Neil gets along with people, even adversaries. There have been stories in the press in which adversaries have already said, you know, honorable, ethical guy. But I'll tell you a story that I always find amusing, and that's this one. When we had an adversary who had this habit of calling me, and we'd have a conversation. Something would annoy him during the conversation. He'd go slam the phone down every time. And that kind of creates wear and tear to have to deal with that. So I finally called the person up and said, "John, I know you like to slam the phone down on me, but the day's going to come you're going to want to take a phone call from me, and I'm not going to take your call. We're not going to talk on the phone anymore." He said, I won't say it because we're on television, but he used a word that, you know, reflected his view of the subject. It didn't give me confidence. He understood my message. So I didn't talk to him on the phone anymore. Fast forward about a year, and Neil comes to my office and said, "John's been calling me." I said, "Why?" He said, "Well, he says you won't take his call." I said, "That's right. I told him I wouldn't." "Well, John wants to pay you $1,300,000,000. I'm not going to take his call." He says, "Mark, take the $1,300,000,000, okay?" I said, "Neil, I'm not going to talk to the guy." You have to understand the pressure that was involved, because at that time, all the final appeals had been exhausted, and an interest was running on this enormous judgment. So John really wanted to get rid of the money, because otherwise you're going to keep paying $300,000 or $400,000 a day. So it was hurting John to not have me take his call. So finally Neil said, "Don't worry, I'll tell you what, Mark, you'll never have to talk to John. Don't worry about it. And Neil went around behind my back, and he called John and said, we'll work this out. Mark's crazy, and he managed to work out all the details of payment without offending me, without annoying me, cooperatively with John. We got the client's interest served. My little homily was made clear to John. It all worked out fine. I could tell you lots of other stories, but I think the important part of it is that Neil is a consensus builder. He finds common ground with people. He has a warm personality. He gets along with people. And we're not sending someone to the Supreme Court to be a lone dissenter or a pariah. I hope we're sending someone to the Supreme Court to work with her or his colleagues, to influence them, to persuade, to be a colleague. And I think Neil has enormously wonderful personal and interpersonal qualities that's going to be very helpful to him in that effort. Hopefully I'm not too far along in my time. I know there's a hook someplace for me if I'm overdoing it. But once we senior partners start to tell stories, there's really no limit. But I'm getting my number 5 on my book of virtues for Neil, and that's what kind of person is he, right? We've been talking about, does he get along with people? Has he got a good sense of humor? Does he work hard? Yeah, it's probably all pretty familiar stuff. But do we know anything about him that tells us what he's like at his core? Do we have something that tells us about character? And I would say that we do. It's one of my favorite stories. And it's this. We had a case for a big investment bank in Florida that we were called in to defend after the judge had defaulted the investment bank. They'd found that the investment bank had committed gross misconduct in discovery, had agreed to treat the plaintiff's complaint as true, even though it wasn't, and had basically said, we're just going to try the case on damages. And so I got hired to do that case as I was sitting there watching another law firm do jury selection. And I'll tell you, my stomach sank, because what am I going to do with this thing? Now, I don't think I can even tell you how scary this was, because not only had the judge defaulted the client, but the judge was convinced that massive obstruction of justice had occurred and viewed with enormous suspicion anyone who had anything to do with this client. So it could be it had career ender written all over it. It really did. I mean, just death to your career. So much so that when the trial ended, the judge held an extraordinary proceeding, the likes of which I have never seen anywhere else, where she considered seriously appointing the other side's lawyer as a special prosecutor under Florida law to conduct a criminal investigation of us with the power to indict us. Now, why do I tell you that story? Because I tell you that story in that after I got hired, I thought, what am I going to do? The other law firm had been fired, and they weren't going to work on it anymore. It's an enormously complicated case. Yikes. I got a stop card. Can I finish this story and then stop? Because that really is the end. I called Neil. Now, Neil was already heading off to government. I mean, he already had his plan to go off and do some time in the Department of Justice. It would have been completely understandable for Neil to say, I got a hair appointment next week. I got to get my hair dyed. Or this really doesn't, I got other things to do. He could have come up with a million excuses. Or he could have just said to me, Mark, my career is too important to me. I'm just not going to strap myself into this burning boat and go down with you, okay? Excuse me while I take a drink. What he said was, when do you need me? He put his career on the line. I think that tells you a lot about the kind of person Neil Gorsuch is. So what America is getting in Justice Gorsuch is a highly intelligent, principled, and experienced man with a deep experience in our civil justice system. That's why I and 40, literally every one of his former partners, sent a letter to the Senate saying, you need Neil Gorsuch on the United States Supreme Court. I would say getting 40 independents, Republicans, and Democrats who won't even agree on the kind of coffee to stock in the kitchen to support Neil Gorsuch is an extraordinarily strong letter of recommendation. Thank you all.
Now we'll hear from a panel of Judge Gorsuch's former law clerks. First up is Jamil Jaffer. He's an adjunct professor at George Mason University's Scalia Law School, where he also founded the National Security Institute, and he directs the National Security Law Program. Jamil worked in the Justice Department's Office of Legal Policy and in the White House counsel's office during the Bush administration, and he served as the chief counsel and senior advisor for the Senate Foreign Relations Committee, and senior counsel to the House Intelligence Committee. He was one of Judge Gorsuch's very first law clerks. He also clerked for Edith Jones of the Fifth Circuit. He's a graduate of UCLA, the University of Chicago Law School, and the United States Naval War College. Second, we'll hear from Janie Nitza. She's a Clemenko Fellow at the Harvard Law School, where her scholarship focuses on national security, criminal procedure, and executive power. She previously served in the Justice Department's Office of Legal Counsel during the Obama administration and as an associate at Kellogg Hanson. Janie is a graduate of Harvard Law School, as well as Harvard College. She clerked for Judge Gorsuch and then for Justice Sonia Sotomayor. And then finally, we'll hear from Matt Owen, who is the staff director and chief counsel of the U.S. Senate Permanent Subcommittee on Investigations, chaired by Senator Rob Portman. He previously served as chief counsel to Senator Mike Lee, as a Bristow Fellow in the Office of the Solicitor General, and as a law clerk to Judge Gorsuch and Justice Antonin Scalia. He's a graduate of the University of Texas at Austin and the University of Michigan Law School. So, Jamil, we'll hear from you first.
Great. Well, thanks to the Heritage Foundation for having all of us, and thanks to Mark for giving such a real tribute to Judge Neil Gorsuch, who really is a truly amazing person. And I thought what I'd do is, for a few minutes, talk a little bit about the person that Neil Gorsuch, Judge Neil Gorsuch, is, and the way he sort of affected my life in particular. I saw him in 3 different capacities over the course of time that I've known him. When I first arrived at Kellogg Hanson back in 2004, Judge Gorsuch at the time was a partner at the law firm, and I was a young associate, fresh out of law school, and a clerkship with Judge Edith Jones, and I didn't know anything about the law, and I started to meet partners and associates and the like, and sort of learn about what the practice of law was like. I will say, Kellogg Hanson is a very unique firm. My first ever deposition of the firm was of a former federal district judge who had been 10 years on the bench, had been the chief judge in his district, had been a partner at Williams & Connolly, and was the chief legal counsel for a major accounting firm. So they really throw you into the deep water fast. But Judge Gorsuch at the time, being an attorney, was a very approachable person. He's a partner, and you expect these partners to be really sort of unapproachable. They're intimidating, they're scary. He was none of those things. Now, he was only at the law firm for a couple of months before he headed off to the Justice Department, and I was there. But in the brief time I knew him there, I got to know a guy who was very accessible, down to earth, approachable, and this held true over the entire course of the, well over, now 13, 14 years that I've known him. So, got to know Neil Gorsuch a little bit there, the judge at the time. Off he goes to the Justice Department. Little did I know that just 9 months later, I'd be following with the Justice Department when Mark was kind enough to let me leave the law firm after only a few months there to go work on the confirmations of then Judge and now Chief Justice John Roberts, then Judge and now Justice Samuel Alito, and White House Counsel Harriet Miers. And so it was a really unique opportunity to see Judge Gorsuch at the time in his role in the Associate's Office. I didn't work directly for him. The component that I worked for didn't report to him. It was the Office of Legal Policy at the time, run by Rachel Brand, who's now a professor at the Scalia Law School and has been nominated to be the Associate Attorney General, the number 3 at the Justice Department. But I got to know Judge Gorsuch in a different capacity, as a practicing lawyer in the federal government. And that was really interesting because I saw him manage an entire set of divisions, the entire civil litigating arm of the Justice Department from the Associate's Office. And he had a very practical view of this. Again, very approachable. He was a young man at the time. As Mark mentions, he was in his late 30s. I was in my late 20s, early 30s at the same time. And then come to find out that the Bush administration was considering nominating him to be a judge on the 10th Circuit. I said, well, this is amazing, right? I knew this guy back when he was a young lawyer or a young partner, and now he's a young senior official at the Justice Department, and they're nominating him to the 10th Circuit. This is kind of crazy. So my boss comes to me and says, hey, can you do the vetting on this guy? And I said, well, actually, I can't. I knew him at the law firm, so I feel like I might be conflicted out. So I can't really be involved in that. But ultimately, they did the vetting. They decided they're going to nominate him to the Court of Appeals. So I said, well, now that they've made the decision, I can help out with the nomination. So I did. This was after all the Supreme Court stuff had finished. And ultimately, he was confirmed to the bench. So then he comes and says, look, I need to hire some law clerks. And I had a friend of mine, Heather Kirby, who had never planned in law school on clerking for any judge. And she ultimately ended up clerking for 2 appellate judges, including Judge Gorsuch, and a district court judge on the Northern District of Illinois. But I said, this guy, so young, so dynamic, he's going back to Denver. Heather's in Denver. She would love this young man. And so I said, you should talk to Heather Kirby. And so he did. He ultimately hired her hired 2 other law clerks, including a friend of mine, Mike Davis, who at the time was moving from the White House to the Justice Department to work in the criminal division, had been a special assistant United States attorney, and he ultimately hired Mike. And Mike, having gone to clerk for Judge Gorsuch for a year, ended up has his own private law practice in Denver. It completely changed his life. He went from living in Iowa, living in D.C., to having a private law practice, his own solo practice now with 2 other folks in Denver, Colorado. And so then Judge Gorsuch had one more spot. And he said to me, you should come clerk for me. And I was it's funny, you look back and you think to yourself, what an idiot I was back in those days, right? I sort of scoffed at him. I said, I already clerked. I clerked for Judge Edith Jones, the queen of the federal judiciary when it comes to folks who are conservative. So I come clerk for you in Denver. That's so crazy. These young partners at law firms think they're going to have me come clerk, right? But he said, he made a convincing case. He said, it's ski season in Denver. So this is a pretty good point. Now, I was afraid actually to leave the Justice Department at the time because I had just been there a year. My plan was actually to go back to Kellogg-Hanson. And I said, I was actually a little worried because, Rachel Brand had given me all these unique opportunities to work on Supreme Court confirmations right out of law school, right out of a clerkship, right out of a few months at a law firm. I was afraid that Kellogg-Hanson was going to be like, what are you, crazy? You're going to go clerk again for, admittedly a former partner. And so I said, I'll make you a deal. I'll come clerk for you if you ask Rachel. Can you imagine what an obnoxious human being it takes to tell a federal judge who's just been confirmed, you go ask my boss, right? So, here we are, and he did, and she said yes, and off I went to go clerk for him. I only spent 4 months with him, but let me tell you a little bit about who he was as a judge, because I saw him move from being a partner law firm to being a federal attorney to being a judge. And what was amazing about that transition was he did it with grace and dignity and honor, and he really did it in a way that makes you think, God, this is a judge's judge, right? He went from being an advocate to being sort of a policy deciding lawyer in the Justice Department, ultimately to being a neutral decision maker. And so going to work for him for the first 4 months was amazing because you watched that transformation. But beyond that transformation, you also saw a young man who was sort of coming into his own. And I remember the first day that Mike Davis and I arrived in Colorado, he took us alpine sledding. This was before the job started, it was on a weekend, so it wasn't a work day. And alpine sledding, for those of you who don't know, is sort of one of the things that people do in Colorado when when the mountains aren't covered in snow, right? You basically take the track down the mountain and you go down this high-speed rail, try and race each other. And the judge beat both Davis and I down the mountain twice and continued to make fun of us for the next 6 months. Because he was like, come on, you guys are young, you're dynamic, whatever, and I can beat you down the mountain. An old guy like me can beat you down the mountain. It's pretty embarrassing. So, and then he taught us how to fly fish. And this is a man who loves fly fishing, right? He's a very normal, down-to-earth human being. I was so bad at fly fishing, by the way, that ultimately he took the fly rod out of my hand and said, look, I'm going to get the fish on line for you, then you reel it in. It's kind of like your dad, right? It's those embarrassing moments. But, when we started working for him, the first thing he asked me to work on was to make sure that he handled the ethics of becoming a judge properly, to look at all the laws and all the statutes and all the regulations and make sure that he handled the fact that he was coming out of a law firm, coming out of the Justice Department, and he handled those things ethically. And so we worked together to ensure that he implemented the rules properly so that he would properly take the office and take it seriously. And he was very serious about that. We spent a lot of time revising the memo and looking at the materials and looking at the various parties that he might recuse from and ultimately making decisions that went well beyond the law and well beyond the requirements, because he wanted to ensure that there was no question that he was doing the right thing. And that's the same way he approaches the cases. He looks at the law first. He then looks at the arguments that the parties are making before him. And he tries to figure out, what is it that the law says about this case before me? He doesn't try to make law for the 40 cases to come in the future. He doesn't look to go beyond the arguments made by the parties. And he doesn't look to go beyond the text of the law. Tries to apply the law faithfully as written by Congress, as drafted by the framers of our Constitution, and apply it fairly and even-handedly to the parties before him. And so with that, I'm getting the stop signal, so I'll turn it over to my colleagues.
Jane.
Hi, yes. So I thought I would just start and talk a little bit first about taking up on where Jamil left off, how the judge approaches cases, and then end with a bit of his personal side. So one thing that struck me from day one coming off of law school is, in law school they sort of teach a little bit of a cynical side of the law. They teach that in a way that sort of the judiciary is a place for doing politics, and a lot of the judges are just sort of politicians in robes. And so I came from off of law school and sort of had this in mind. And so it was a real shock to me to clerk from day one for a judge that conveyed from really the moment, the first case I had with him, that is not how it goes in his chambers. And his chamber is all about the rule of law. And it's all about a place where the judiciary is not a place for doing politics. It's not a place for personal preferences of the judge. It's a place for rule of law, for, as Jamil said, sort of the text of the statutes, text of the Constitution, what did the framers originally understand, what was originally understood at the time the Constitution was enacted, what do the precedents say, what do the arguments say. And so that really struck me because I had, even to this day, conversations with friends where they have sort of a very cynical view of the judiciary. And I think that one thing that I feel very sort of blessed about was to have had the opportunity to clerk for someone who conveyed to me this deep, deep, deep sense that our democracy can only function if it is in the elected, or if it is in the represented branches where policies are being done. So that was the first thing that struck me. And then the second thing that struck me was the way in which he approached all cases, whether they were high profile, low profile, it didn't matter, with an enormous amount of care and respect. I remember one case in particular, I won't get into the specifics of it, where it was very much, not a low profile case. It was not a case that was going to get into the newspapers, but he had not one but two clerks sort of sift through the record, because it was a tricky question that turned on sort of some of the factual aspects of the record, and we really sifted through it for hours and days and weeks to get to the right answer, and that's typical of the judge with all of his cases, and so that struck me as well. And then on a personal side, I'll state that the way I came to the judge was I put together in law school so this list of judges that I wanted to clerk for. I was one of those very early clerks, so when I was applying, he'd been on the bench for probably a year and a half. I hadn't heard of him. I had my list of 20, 30 judges I was going to apply for, and a friend of mine took a look at the list, and he ran through and said, this looks good, but you should really add this judge, Judge Gorsuch. He just took the bench. I heard him give a speech, and he seems just brilliant, and I think you should go and take a look at him. So I applied. I was fortunate enough to get an interview with him, and I actually confess reluctantly that I wasn't sure. So the day before the interview, did I really want to fly out to Colorado? Was I going to clerk there? I wasn't sure, and I was even debating possibly canceling. So I flew out there, and by the end of the interview, just thought, if he offers me the position, I would just be blessed to clerk for him, because even within the short span of sort of 30 to 40 minutes, I could see with his questioning of my writing sample, sort of his brilliance and this incisive questioning, and also just what a kind, decent man he was, and there was a real warmth that radiated from him. And that has been my experience with him. So I've known him now for 10 years. He's virtually the first person I call whenever I have any question about my career, or sort of really even some aspects of my personal life, and he takes the time on the phone to talk it through with me. He offers any help that he can give, and he's been a true mentor to me and a lot of folks. And on that, I'll just end on one last story. Many students apply to the Supreme Court right in law school and get accepted to a Supreme Court clerkship right out of law school. And I didn't apply, and I don't even recall applying during my clerkship. And I just thought it was something that was just out of reach, wasn't going to happen for me. And it was really the judge that just pressed day in and day out, you should really apply, and that encouraged me. And he's, thanks to him, I was fortunate enough to have a later experience of the clerkship on the Supreme Court. And that's just an episode that demonstrates really, his mentorship qualities and how he's looking out for really everyone. So I'll end on that and turn it over to Matt Owen.
Thanks, Jenny, and thanks to the Heritage Foundation for having all of us. And I also wanted to thank Mark for his address, which I also thought was really interesting, because we all came to know, except Jaffer, I guess, the rest of us came to know him after his days as a lawyer, and we have over the years heard some stories, war stories, from Mark and his partners and other people who appeared with and against and around the judge when he was a lawyer in civil practice, and we understood that he was a pretty remarkable lawyer, but it's a part of his life that we didn't get to see, so it was nice to hear about. Oh, I guess I'll reverse the order in which Janie took this. I want to say something personal about the judge, and then maybe say something a little bit about his cases and his approach to the law. It's funny how we all came to clerk for him. I came to clerk for him because I had an interview with a different federal judge on a Wednesday, and this judge is famously very rigorous about interviews. It was a very grueling kind of all-day process of talking to his law clerks and him about everything I knew, which wasn't very much as a second-year law student. And then I flew from that interview to Denver to meet someone who I confess I didn't really know very much about, except that his name was Neil Gorsuch, and he was a judge, and that professor of mine who was sort of my mentor in law school, her name is Joan Larson, who's a terrific judge herself now, was friends with Neil Gorsuch and said, he's new and he's great, and you need to go clerk for him. And so I show up in Denver, and we have you talk to his law clerks, then you sit down with the judge, and in about 30 minutes, he managed, while being entirely kind of gentlemanly and polite, to poke at 3 or 4 questions about my writing sample in my classes that were real questions that got to the point. But meanwhile, to learn what I was planning to do over the weekend while I was there. Was I planning to go hiking? Where was I going? Would I like to stop by his cabin because all the law clerks were going to be there on a hike, and make sure I got somebody's phone number to make sure I did that. And he was from the beginning, from the first minute before he ever offered me a job, the most welcoming person in the world about being in Colorado and being around him and his the sort of extended family that became his. All of his law clerks, and that was. It feels like an age ago now, and to look back on it, knowing that he's now the nominee of the president to be on the Supreme Court is something special for me and all of us, I think, who clerk for him, particularly those of us who clerked a long time ago. I'll also echo something that Janie said, is that he's as a human being is tremendously honorable and kind. To people that know him, I can attest that when I remember having. I think everyone has rough days. In a particularly rough day in my life, I got a call from the judge who had sort of heard about it, and he made it. All I can say about it is he made it his business to make sure that whatever was going on was going to be put right, and he was going to do that himself, which he did, and it was it meant a lot. It meant a lot to me. And particularly because I had the privilege to clerk for Justice Scalia, whose seat this is. It is really meaningful to me to know that the person who's going to take Justice Scalia's seat on the court is not just a conservative in his tradition, but is also a good man. I do want to say something quickly about his jurisprudence, though, too, because he's been compared in the last few months. To Justice Scalia in lots of ways, maybe not in what we might call the vociferousness of his dissents. I don't think that you can look forward to quite the same kind of biting dissent from Neil Gorsuch as we used to enjoy reading from Justice Scalia. But what I do think you can expect is a similar approach to the law, textualism when it comes to statutes, and originalism, history, and rigorous attention to the law when it comes to the Constitution. If anyone remembers when they were in like grade school or high school having to diagram sentences, there is a published opinion of the judge explaining the meaning of a federal statute by putting a sentence diagram in the opinion, and it actually makes it very clear. You want to know, like, which word does this phrase modify? And well, I'll show you, right? It illustrates a really deep commitment to the things that, for me, it's important to say, Justice Scalia kind of taught us all. After he died, everyone took a moment to notice how much Justice Scalia had changed the way lawyers and judges talk and think about the law. And one way you know that is that nearly 30 years after Justice Scalia became a justice, the person who's nominated to take his seat is a person who diagrammed a sentence in a judicial opinion rather than leafing through the legislative history. I was going to say something about a constitutional case, but actually, maybe in keeping with the theme of Mark's speech, I have something to say about the judge's attitude towards civil litigation. He was a trial lawyer, and he understood that part of his job as a Court of Appeals judge was to ensure that trial litigation is efficient and fair. And so years after I clerked there, I got he sends out his opinions to his law clerks, occasionally, and we pretend that we read them all, but we read some of them. And I remember reading one that was, it was a published opinion of the Tenth Circuit, and anyone who's watching who's a lawyer will know what this means, about a discovery dispute. What had happened is that a trial judge had sanctioned a party for not producing a document that they were supposed to produce on time. And then they'd been told to do it a second time, and they still didn't do it. And the trial judge lost their temper a little bit and dismissed the case. And maybe in the course of dismissing the case, the judge didn't recite all the things that you're supposed to recite and consider all the factors you normally are supposed to consider. But the conduct of the party was really outrageous. And the judge wrote an opinion that has been cited a lot, and I understand district judges all across the country are grateful for, which says, no, discovery is not a shell game. I think that's the line. You cannot, hide documents, prolong litigation that costs people, real people, time and money. And if a judge decides that if you bring a lawsuit and you won't comply with discovery orders, they want to dismiss your suit, that's fine. Right, and it's a small thing, but actually, if you've ever practiced civil litigation, as all of us know, partners like Mark say, "Hey, go find a case where when somebody did this terrible thing to us, the judge came down on them." Those cases are very hard to find. You can spend a lot of time because Court of Appeals judges don't like to hear discovery cases. They like to write about constitutional law and the Fourth Amendment and religious freedom and all the things that we all like to talk about. But Judge Gorsuch understood that part of his job is to make sure that ordinary civil litigation for ordinary people is conducted as efficiently and fairly as he can. And I know that interest and commitment that he learned from being a lawyer and what he knows is important about how the justice system really operates for real people and real parties and real cases is going to go with him to the Supreme Court. So with that, I'll turn back to Elizabeth.
Thank you. So now we have time for a few questions from the audience. We have a few ground rules. Please wait for a microphone and identify yourself. And please ask a question, don't make a speech. Any takers? Over here.
Hi, Paul Kavanaugh. I had the fortune of knowing the judge when he was in private practice. But my question, I guess, is probably to the law clerks. In terms of his work ethic, it's clear. When he's going to be on the Supreme Court, do you think he would join Justice Alito in terms of reading his own cert petitions there or be part of the cert pool? And there's several cert petitions pending that will be before him after he's confirmed, especially in the criminal law, the DeCosta case, and there's a Farhar case on a mens rea. So I'd just like to know, what do you think about that, and what's his view on criminal law jurisprudence? Thank you.
I can take a shot at some of that. I know Justice Alito is no longer free. For those of you who know, the justices, most of them except Justice Alito, pool their law clerks to help review the cert petitions that come in, the petitions for asking the court to review a case. And it is, having written these pool memos, it is a tedious part of every law clerk's week. Justice Alito is not in that process. He likes to have his clerks review all the petitions under his own standards. But that wasn't true the first year he was on the court. As I remember, Justice Alito was in the cert pool for a while until he, got his feet under him on the court and then decided what he wanted to do. So I don't know whether the judge has any particular plan about that. I'm sure we'll all find out. But I'm also, wouldn't be surprised if you can change your mind about that over time. On criminal law jurisprudence, I don't know if anyone else has an opinion about that. I think there are a number of cases where, like Justice Scalia, if the law says the defendant gets to win, the defendant gets to win, and that's sort of the end of it. Sometimes there are particular cases where the judge has taken a pretty rigorously textual approach to a criminal statute that disfavored the government, and his opinions to me, reflect the same kind of approach to that Justice Scalia had.
And I think the important thing to know about that is, Justice Jackson was the Attorney General before he was nominated to the bench. And one of the things that was really interesting about Justice Jackson was he really took on the role of a judge very seriously, which is he was an advocate when he was in the Justice Department and immediately switched to being a neutral decision maker. And I think that people who look at Justice Jackson's jurisprudence will say that was a man who really took that craft seriously. Judge Gorsuch is very similar, I think, in that way, in the sense that, he's having been a Justice Department senior official, that doesn't bring with him any baggage. He looks at the law for what it is and decides the case on the law, not on sort of a view of how this should come out, whether for the government or for the defendant at the end of the day. He has spoken a bit about overcriminalization also and talked about the challenges that overcriminalization presents for the judicial system and for parties who are trying to govern their own conduct.
If I can add something to that, I don't know if you guys agree with this, but I think if he took something from his senior service at the department to his job that relates to criminal cases, it's that he has enormous respect for the Department of Justice, but also very high expectations for their behavior and the quality of their advocacy and briefing. And he could be known to get a little hot under the collar at oral argument if he thought that the government was cutting corners in a criminal case.
And I'll add actually something just as well. As Mark Hansen alluded to, a lot of folks have talked about his writing style and how clear it is. And part of that, I think, much in the line of Justice Jackson, is about having ordinary Americans understand what the law requires of them. So sort of to a little bit the over-criminalization point that he wants ordinary Americans to be able to either, both read this Texas statute, understand what's required of them, and also read judicial opinions, understand likewise what's required of them.
Thank you for a wonderful panel. I'm Star Parker, the Center for Urban Renewal and Education, and syndicated columnist with Creators. Mr. Jaffer, you mentioned several times now that he looks to existing law, and I'm wondering, well, you said looks at the law first. Is that existing? Is it all laws leading up to the existing law? Is it the way that he would interpret constitutional law? What worldview does he come to the table when you talk about he looks to the law?
Yeah, and I think Matt talked about it a little bit. I think that the judge looks at the law that's applicable to the parties, right? So in any given case, you're going to have a law that existed at the time the parties' conduct took place. He's going to apply that law, right, based on the arguments made by the parties before him to the case before him. As Janie mentioned, he's not looking to be a politician in a robe. Right? That's a really important thing. Today, I think in our country, and this is true both on the sort of conservative side of the spectrum and the liberal side of the spectrum, too often when we don't get the outcome we like in the political process, we run to the courts and say, courts, you solve this for me. You fix the law because I didn't get what I want out of the political process. And this is a problem on both sides of the aisle. And I think Judge Gorsuch's view of the judiciary, and I think correctly, based on our framers' view of the judiciary, is that's not the job of judges. Judge's job is to decide cases based on the law that Congress passed, the president signed, or Congress overridden veto, right? And that's the political process. So if you have a problem with the laws, there's a way to do that. You have elected officials, you can vote them out of office. You don't go run to the courts and have the courts solve that problem for you. Now, when you do have a case before the courts, it's important that the judges look at the law, whether it's the Constitution or statutory law, and apply it fairly to the parties before them with no bias towards one side or the other, no predisposed notion of the way this case should come out, and no importing of their own personal policy preferences into that. It doesn't matter what the judge thinks the right answer should be. The question is, what is the right answer under the law? And that's really important. I think that's what, in a lot of ways, makes Judge Gorsuch a judge's judge. And that's, I think, what we want. I think at the end of the day, even though we often run to the courts as as a very litigious society, I think at the end of the day, Americans really want judges to do that job and not the job of politicians. And I think that's the kind of judge Neil Gorsuch is. And I think if he's lucky enough to be confirmed to the Supreme Court, I think it's the kind of justice he would be.
I have a question for the panel. So everyone is familiar with the pretty famous friendship of Justice Ginsburg and Justice Scalia. Particularly for Janie and Matt, since you clerked for Supreme Court justices, do you see any of the current justices and Gorsuch sort of becoming fast friends?
I can take a first stab at this. The judge is sort of known on the 10th Circuit as being friends with sort of everyone on the 10th Circuit, and this goes back again to what Mark Hansen is saying. He's just a very personal, warm guy, and so I can't speak to sort of any particular justice that might they become particularly close to, but I would certainly expect that he would fit in well in the court and that he would make fast friends with all of them.
It's worth remembering he clerked for Justice Kennedy a long time ago, so I know that I'm sure that's a special thing for both of them if the judge is confirmed to sit on the same court together. It's as you can all tell or know, being someone's law clerk is an important relationship, and I'm sure he's looking forward to that.
I think we have time for one more question. If not, well, join me in thanking our panel.